Our next speaker is Samuel Levine, professor at Pepperdine University School of Law. His topic today is Rediscovering Julius Henry Cohn and the Origins of the Business Profession Dichotomy. Professor Levine has written on Jewish legal theory and American constitutional theory and American legal practice through a perspective of Jewish law, ethics, and tradition.
Thank you, Steve. And thank you, Steve. I'm looking forward to seeing the book. And thank you, Suzanne, and the planning committee for organizing such a wonderful conference and for inviting me to participate. Can you hear?
Gotta get in a little closer.
Okay.
Pull it closer.
Since at least the earliest years of the 20th century, prominent segments of the legal community have accepted and adopted the assertion that the law is no longer a learned profession, it has become a business. In response, the past century saw repeated and sustained professionalism movements aimed at promoting an ideal of professionalism in legal practice. Each of these movements was confronted by various forms of criticism and opposition on both descriptive and normative grounds. The prevailing division among leaders of the practicing bar and the legal academy alike has produced, in the words of one scholar, a perennial debate. To many of its critics, early 20th century legal professionalism was characterized by, if not premised upon, numerous vices, including anti-Semitism, nativism, classism, economic protectionism, and general elitism. My article, which is published, and I think you have before you, considers the discourse and underlying attitudes of early 20th century legal professionalism through a close analysis of Julius Henry Cohn's 1916 book, aptly titled, The Law, Business, or Profession. I suggest that although Cohn shared and relied upon many of the concerns of his contemporaries over the commercialization of legal practice, he offered a unique vision of professionalism, one that eschews notions of bias and self-interest in favor of intellectual honesty and a sincere concern for the good of society. The part of the article I want to focus on in the context of this conference, drawing in part on what we talked about yesterday and what Steve talked about, contrasts Cohn's rhetoric and underlying approach to professionalism against the often anti-Semitic, nativist, and classist attitudes expressed by leaders of the organized bar in discussions of professional misconduct and bar admission standards. Other parts of the article, which I don't expect to focus on right now, consider Cohn's support for stricter standards in legal education and prevention of the unauthorized practice of law, in spite of his rejection of the kind of economic protectionism that often accompanied called by others for higher standards, and Cohn's ability to promote law and out of business without engaging in the elitism popular among segments of the legal community of his time. In his study of elite lawyers of the 20th century, Gerald Auerbach develops a thesis that in the early part of the century, although lawyers spoke the language of professionalism, their vocabulary often masked hostility toward those who threatened the hegemony of Anglo-Saxon Protestant culture. Based on the rhetoric of leaders of the organized bar who called for stricter educational and admission standards, Auerbach argues that professionalism and xenophobia were mutually reinforcing, finding expression in anti-urbanism, anti-Semitism, and nativism. While some have disputed Auerbach's assessment of both the prevalence and influence of these attitudes, there appears to be broad historical support for Robert Stevens' finding that, quote, wherever one looks in the literature of the period, the establishment expressed concern about the background of those who were alleged to be demeaning to the bar. Auerbach's documentation of anti-Semitic and nativist rhetoric underlying early 20th century calls for professionalism provides a helpful setting for a consideration of Julius Cohn's unique approach. In support of the thesis captured in his title, that law has become a business rather than a profession, Cohn dedicated most of the first half of the book to a critique of the standards of training and education required for admission to the bar in the United States. However, a careful reading of Cohn's extensive argument reveals an apparent absence of any form of bias on the basis of class, ethnicity, or country of origin. Instead, in formulating both the substance and language of his argument, Cohn consistently relied on an intellectually honest analysis of the issues rather than vituperation and innuendo. Cohn maintained his own rhetorical integrity while at the same time allying himself with and relying on leaders of the legal establishment whose public statements reflect the kind of prejudice noted by Auerbach and others. One of the most prominent figures in Cohn's book, mentioned by Steve, is Charles A. Boston, who at the time the book was published was chairman of the Standing Committee on Professional Ethics of the New York County Lawyers Association. Boston first appears in the book's opening pages as one of two individuals Cohn acknowledges for the inspiration and leadership in work that makes the natural occasion for this book. Elsewhere in the book, Cohen describes the unique circumstances of his close relationship with Boston as part of what he describes a group of lawyers who met socially to discuss among themselves the practical questions that come under their observation, where the application of principles of ethics to actual situations become necessary or advisable. Cohen refers to the group, with a capital G, a self-consciously elitist group in its membership. It was small in number, and the identity was to be kept entirely private and confidential. Writing with apparent pride, Cohen notes that while the group has been together for 8 solid years, the identity of its membership is still known to but a few. Cohen considers Boston largely responsible for the development in this country of a new and vital interest in the ethical relationship of the lawyer to his client, to the court, and to the public. In a footnote, Cohen cites numerous speeches and articles by Boston, his friend, on the subject of legal ethics, including a piece in the May 1908 issue of the Greenback. Like Cohen, Boston decries a decline in legal practice from what he calls an honorable profession to a trade. Unlike Cohen, however, Boston resorts to language that portrays not only the kind of masked hostility that Auerbach describes, but actually an open animosity toward groups that, in Boston's view, possess characteristics unworthy of lawyers and were responsible in part for what he called the deterioration of the bar. Boston nostalgically recalls the days when Alabama, for example, was a homogeneous community where the law was an honorable profession and not a trade, and where the practices of many races, and this does not refer to African Americans who weren't really involved in the bar at the time for other reasons, and of commercial craft had not destroyed notions of ethical standards. In an analysis of the conditions in the largest cities, Boston declares that in New York, many men select the practice of law as a business, and some are, I fancy, ignorant of ethical standards. Success, as they define it, is the only standard they know. Boston regrets that the bar is too numerous and too heterogeneous for any central influence. He lists forces working for deterioration, including the ambitious and intellectual capacity of Oriental immigrants, again not referring to the Far East, with no apparent conception of English or Teutonic ideals. The terms that Boston uses clearly are indicative not only of nativism, but of open anti-Semitism, an attitude that was not uncommon among leaders of the organized bar. Just a few years after the appearance of Boston's article, Walter George Smith, in the annual address of the chairman of the section on legal education of the American Bar Association, echoed Boston's sentiments, describing the misfortune resulting from, quote, the mixed character of our population, and again, the steady influx of races that have none of the traditions that centuries have handed on to those who have inherited our ancient ideals of private and public honor. Using many of these same code words, Smith speaks of ambitious youth and voices regret for not having succeeded in keeping undesirable men from the bar by the intellectual test, at least not in larger cities. According to Smith, it is the universal observation that a class of practitioners have come to the bar who are totally lacking in a high professional feeling that has been our tradition, whose objects are purely commercial, but who never fail in any intellectual test that may be applied to them. 2 years later, again addressing the ABA, Smith apparently found it unnecessary to cover his anti-Semitism with even the thinnest veils, dispensing with the code words and plainly stating that, quote, we have in the eastern cities many representatives of the most ancient race, of which we have knowledge, coming up to be admitted to the practice of the bar. They are gifted with a marvelous intellectual ability and great power of concentration. They exercise extreme self-denial in overcoming their environment of poverty. Frequently, it has been my lot to see men of that character who are surprised when informed that they have done anything wrong. Moving from anti-Semitism to a broader form of nativism, Smith adds that, quote, those who come to the bar without the incalculable advantage of having been brought up in the American family life can hardly be taught the ethics of the profession as adequately as we desire. Smith connects these attacks to a more general, quote, truism among us who practice in the larger cities, that there has come a change in the tone of the profession, a lowering of standards, a commercializing.